Hello, we are here to discuss cases of business law, two of them. The first one is which is the advertising negligence, and the second one is the duty of care. So the Atiq will do the issues, Omkar will talk about the rules, Harneet will talk about the applications, and Amir will do the conclusions. So the first case is where Jenny receives a brochure which says $10 for the manicure and massage, and Jenny thought that's a good deal as that's a new salon, and she books the appointment there. She drives 30 minutes there, and after driving there, she finds out that the advertisement was wrong. It was not $10, it was $100. The manager lets her know about that. But we're going to talk about if Jenny drives 30 minutes there and did not know about the $100, and she gets the massage and manicure done, and then she finds out it's $100. Is she going to be paying the $100 or the advertising fee $10? So Atiq will do the
issues. I'm here to represent the issues. The question raised that whether there is any misrepresentation made by the advertisement that best hair salon in the circular or not. Also, if the misrepresentation has been made, then what would be the implication of it in two different scenarios, where the manager of the salon has accepted the misrepresentation and told Jenny the right price before the message and manicure service has been delivered, or the acceptance has been made after the message and manicure service has been delivered. Also, in case the manager tell about the misrepresentation after the delivery of message and manicure service, then would Jenny be liable to any claim for damages for the amount she had to pay due to the misrepresentation made on the circular?
So now I will explain the rules for this case study. Definition of misrepresentation: the statement that is not made on the basis of facts. Types of misrepresentations: fraudulent misrepresentations, the false statement is given knowingly. The second one is an innocent misrepresentation, lack of element of intention. And the third one is negligent misrepresentation. The maker of the representation innocently makes a wrong statement but with the element of carelessness. So in the rules section 29(1) of the Competition and the Customer Act 2010, as per which a person who is in the trade of commerce or in the business of supplying services should not make false and misleading statements about the price of goods and services.
So now we talk about the application. First we talk about the fraudulent misrepresentation elements. Existence of untrue representation, existence of false statement about facts, and third one is the person who is making the representation should know he or she is making a false statement, the belief that the other party will rely on the information and act on that. The party that is innocent must have suffered a loss. So now we talk about the innocent mispresentation. The Business Law 2014, page number 439 states that it is not a tort, and also if the mispresentation is not in the form of contract, then the other party has no action for remedy either under contract law or in equity. Case like Oscar Chess and Williamson, 1957. Negligent mispresentation. Element of negligent mispresentation which are as following: existence of special relationship and the other duty of care was earned. Subject matter is serious. The person stating that must lies that the other party would act on it. The other party must suffer a loss.
So by concluding this question as stated in the application section, the manager of the saloon told Jenny about the mistake that appeared, and circular accepted the mistake also. Therefore, as this was told before the service was provided, hence there would be no contract, no result, and no liability. However, if that would be intentionally a case, then it would have a fraudulent and misrepresentation. That's it from the question number 1.
So we go with the next case, in which there's a fire brigade which is designed to carry large jacks. So that vehicle is actually used in another incident at the moment, and then the fire brigade, they get another call for another accident near the headquarters. So the officer on duty asked to take the jack which is required for that accident and put it at the back of the brigade. and take it over there. While on the way, they had a hard break on the intersection, due to which the jack swung up and injured an officer. So we're going to talk about if the officer in charge has breached his duty of care in placing the jack on a vehicle that is not specifically designed to carry it.
Once again, I'm here to represent the issues. The issues that relate to the case of bushfire breach here relate to the fact that whether an order that was given by the officer in charge of the bridge to carry the jack on the available vehicle other than the specialized, on which ultimately ended up in the injury of the fire officer, is a breach of duty care or not? If yes, then the relevant rules are to be applied in order to target the issues.
So the rules are that applies in this case study. Salient feature test is used to order to determine that whether the duty of care exists, and also the test of proximity is also used in order to reach to the conclusion that whether the duty of care exists. Second, whether it was breached. Force ability test is also used in order to determine the duty of care as per this test. The question rises that whether the responsible person would have foreseen that there was chances of getting harm or injury while taking account of all the circumstances.
So now we talk about the application of on the other question. It can be seen that the special jack was actually designed to fit it with a specialized vehicle and not with any other vehicle, and probably this particular point was known as officers in charge. But still, as per the given scenario, the officer in charge ordered to carry the jack with the other vehicle, which they did, and it resulted in the injury of one of the fire officer. Neighbor test, which was established after the case of Douglas and Stevenson, as per which a reasonable care must have been taken to avoid acts and the concentrated loss or damages, injuries to the neighbor.
So by concluding this question number 2, I'm going to say the officer in charge owed a duty of care to the fire officer, as he was the one who knew about the specialization in nature of the jack, and to which the truck was used. It should be used by others relied upon the decision that are taken, and then they are relying on the decisions. Duty of care existed and it was a breach, therefore the liable and the penalized by the jack.
So this is the whole presentation from our group, and I hope you like it and appreciate about our work. Thank you
Thank you
very
so
much.
much.